Objection, Your Honor.
Objection, Your Honor. Lack of foundation.
Objection, Your Honor.
Objection, Your Honor. Unfair extrapolation.
In mock trial, judges are able to determine how well prepared a team and its individual members are by the way objections are made and how team members respond to objections made by the other side. Making objections the right way and being able to explain to the court why an objection is made requires knowledge of the rules of evidence as well as mock trial. Practice is critical in order to make good objections and to develop the skills needed to know when to object. Jim Van Dyke is a lawyer from Carroll. He is a successful mock trial coach both at the junior high and high school levels.
The first thing that's important is when to make the objection. And there are judges who say you should go ahead and stand up and make that objection as soon as the objectionable material starts to come into the answer. Others say you better wait until the answer is all the way in. It's impolite to interrupt, so you probably should just wait. When the answer is done, then you stand up. Make the objection. Your Honor, I object, and I move that my objection precede the answer and that the objectionable portion be stricken from the record.
I ask that my objection precede the witness's response, that it be stricken from the record.
My perspective is the polite way. That is, wait for the answer to come in. Now, there are times you can make objections before the answer. If that question is so obvious that it calls for objectionable material, you can go ahead and make the objection before the answer. In fact, that's really best. But most of the time in mock trial, you won't get that opportunity. You'll have to wait, you'll hear the answer, and then you stand up and, in addition to the objection, make the motion to strike.
How should a student lawyer respond, or must a student lawyer even respond if the presiding judge asks a question about the objection that's been made?
I think it's very, very important for the other side to respond. I think that usually the method I prefer is that you get on your feet, Your Honor, may I respond, please? And then 9 times out of 10, the judge will say, yes, you may, and be ready for your response, not only with why you think the matter should, or the objection should not be sustained, but also, if you have it, a rule number is very preferable, that, Your Honor, under Rule 703, this is properly admitted evidence because. And then the person making the objection is allowed one further argument in support of his or her objection.
There are a number of objections available to mock trial attorneys, but there are 5 which are most frequently used. They are relevancy, foundation, hearsay, lack of personal or professional knowledge, and unfair extrapolation.
Where did you all grow up at?
Well, we're all from, Iowa. Like, again, Vermeer is kind of outside of Pocahontas.
Objection, Your Honor. This question is irrelevant to the case at hand. It doesn't matter where the band members grew up.
Relevancy is probably the single greatest objection that any mock trial student can learn. And relevancy simply means, is it important? Does it advance the case or not? If I ask you what you had for lunch, that is probably irrelevant unless the trial might be something like a case involving, say, alcohol consumption. And the expert witness would say that the rate of alcohol consumption can be affected by food intake. So relevance is very, very vital to understand, and it just comes down to, does this question, does this answer advance the case?
Objection, Your Honor. Lack of foundation.
Foundation is pretty much like it sounds. Foundation would be the building blocks that you must put underneath the evidence before it can be admitted. And I like to tell the students I coach that it's the 5 W's. It's the who, what, when, where, and why. Who made this exhibit? Why was it made? When was it made? What purpose does it serve? And then you offer the exhibit or you offer the question, but only after you've done the building blocks of the foundation first.
Objection, Your Honor. The witness has just begun to testify to hearsay.
Lawyers have made a living writing books on the question of hearsay, but very simply, and the way I coach the students is to recognize hearsay by, I heard someone else say. And if you hear the witness start into that sequence, you know that hearsay is coming. Or if the question says, what did you hear someone else say, then you object immediately. Hearsay is an out-of-court statement made by someone other than the witness who is now testifying that is offered to prove the truth of that statement. So there's 3 parts. It's out of court, made by somebody other than this witness, and it's offered to prove the truth.
Objection, Your Honor. The witness has no personal knowledge in the area they're questioning.
Lack of personal knowledge in mock trial usually means that it's outside the witness's statement, because our rules require that the witness stay within the limits of the given facts in the statement. And that means that the witness is not even bound by things in another witness's statement, just his or her own statement. Then there's the professional part of that same objection, which usually relates to an expert-type question. If I ask a mechanic about a medical question, it's going to be lack of professional knowledge. But if I ask a doctor about a mechanical question, the same thing. So an expert, the objection very often is, Your Honor, the witness lacks professional knowledge to give this opinion.
Objection, Your Honor. Unfair extrapolation. The witness has begun to invent facts.
This objection, as you know, does not exist in the rules of evidence for either the federal or state courts. But in mock trial, we are confined to the 6 witness statements and the exhibits, and it is very, very limited on direct examination, somewhat more open on cross-examination, where witnesses can add a few facts that are not in the statements, but only if they do not unfairly change the emphasis of the trial or the direction of the trial. It's one thing to invent a fact to say that I saw a blue car drive down the street when it isn't a real big point in the case. It's another thing if that blue car happens to be the one involved in the accident, in the case involved, and the car actually happened to be yellow or some other color. So if you're inventing a fact that affects the case, the objection is unfair extrapolation. Your Honor, the question asks the witness to invent facts.
My name is Katie Cluse, and my team and I are representing the defense in today's case.
Pretrial conference is very important. It sets the tone for the entire trial. You are establishing a professionalism with the judges. You are showing the judges that you're prepared, you're confident, you're strong. You have a checklist. You're going through the introduction of your teammates. You're going through the stipulations. You have usually a pretrial notebook to hand to the other team and to the judges with all the exhibits and the witness statements to show that you are ready for this trial. And also, it's important at the pretrial conference to bring up some key points that you think might lead to rules questions in a particular trial. If you think that there might be something the judges should be alerted to, bring that up at the pretrial conference. And always remember, for the plaintiff side or prosecution side, reserve time for rebuttal on final argument. There are only 2 times to do that, and one of them is at the pretrial bench conference.
Relevancy, foundation, hearsay, lack of personal or professional knowledge, and unfair extrapolation are not the only objections that are available to a mock trial lawyer, but they are among the most powerful. With practice, the skills to use these objections successfully can be developed, and you as a mock trial lawyer will be able to prevent the other side from presenting evidence and testimony that could hurt your case. This has been a presentation of the Iowa State Bar Association, the Iowa State Bar Association Foundation, and the Young Lawyers Division of the Iowa State Bar Association.